part two of removing the Electoral College because it's not sufficient to simply want to remove it. The question is it constitutional? Is it illegal? The answer will be yes, but of course I have to prove that. To start, we must acknowledge that the provisions within the Constitution can be categorized within two distinct categories. The first one is constitutionalism. These are provisions that are pillars to our constitutional republic, such as the right to bear arms. The right to bear arms is not supposed to be eliminated. However, it can be restricted under the Equal Protection Clause because at the core, the main right that the social contract of the Constitution attempts to safeguard is the right to life of recognized persons. The right to bear arms is simply self-defense in order to protect the right to life. The Equal Protection Clause allows for regulations, not elimination, of the right to bear arms if the right to bear arms is becoming a significant danger to the right to life of people, which it is. So that's a reality where it is capable to regulate a constitutional liberty. However, we cannot eliminate it because it is such embedded into our history because the Second Amendment clause was actually positioned in order to create an unofficial militia for the United States. In the case that our military is for some reason not useful, then the American people will raise up in arms in order to protect our country from foreign invaders. The second category is originalism. This is basically just doing things because our founding fathers wanted us to, is based on opinion rather than actual legal authority. The Electoral College is one of these. It's actually a compromise similar to the 3/5 compromise where 3 of every 5 black enslaved and free persons were considered one white person. The founding fathers created the Electoral College because they didn't trust ordinary citizens to be informed enough to adequately pick the president. They also worried that citizens would band together based on personal interest rather than the overall good of the people, of the nation, which basically means that the Electoral College is literally a conservatorship like the one Britney Spears had. Like literally, it is a conservatorship that Congress has positioned on us because they do not trust that we're smart enough to pick a president. You see, conservatorship is literally someone who is unable to provide properly for his or her personal needs for physical health, food, clothing, or shelter. And really, the Electoral College is really just a way for the state Congress to have control over who is positioned in the presidency. The Electoral College was established as a compromise between the election of the president by a vote in Congress and election of the president by a popular vote of qualified citizens. So there were founding fathers who were like, we should have a popular vote, one person, one vote. And then there was founding fathers, particularly from the southern states, from the small states, who were like, how about Congress decides the president? And they were like, no, but how about qualified persons who are neither the Congress nor American people, individuals, get to decide the president? And that was the compromise. This already is telling us that the Electoral College wasn't actually based on any legal or constitutional reasoning, but rather the preference of our founding fathers and a compromise, such as the 3/5 compromise. The 3/5 compromise, which was in our original Constitution, was overturned not because the Congress people were convinced from some moral aspect, but because the 3/5 compromise actually served to give personhood to black Americans, to enslaved people. Because what it did was say that, no, they're not full people, but 3 out of every 5 are count as one full white person. So the question became, so why are they not full people? And there was no answer that wasn't racism, which is an illegal argument. And this is why after it was removed, we see a dedication to eugenics because you cannot prove through law that black people are not people. How about through science? But the distinction here is that something like the right to bear arms is constitutionalism, and something like the 3/5 compromise and the Electoral College is originalism. This struggle between constitutionalism and originalism is no better witness than when talking about our court. Article 3 of the United States Constitution actually isn't sufficient. It's incomplete because it doesn't actually structure the Supreme Court or the courts. What they actually rely on is Federalist 78 through 83, but that's not the Constitution, because Article 6 says the Constitution is the law of the land, which means that Clarence Thomas, and doing what he did, isn't actually breaking the Constitution, because there's nothing in the Constitution that says that it's a violation what he's doing. It's also questionable whether we can input limit on their terms, because what Article 3 does say is that judges both of the Supreme and inferior court shall hold their offices during good behavior. Federalist 83 positions that the true test of a just application of them is its conformity to the source from which they are derived, that is the United States Constitution. Federalist 81, I admit that the Constitution ought to be the standard of construction for the laws, and that whenever there is an evident opposition, the laws ought to give place to the Constitution. So it's questionable whether we can limit their terms, but what we can do is remove them for not doing their job. However, we really don't have those guardrails because it's not in the Constitution, which means obviously we need an amendment to do that. But it's also restricted through originalism. Originalism is what our founding fathers wanted our Constitution to be. The Alexander Hamilton closed this removal of the judges for not being capable of doing their jobs, and Federalist 79. The want of a provision for removing the judges on account of inability has been a subject of complaint. So people have had that conversation and they're arguing about it. But all considerate men will be sensible that such a provision would either not be practiced upon or would be more liable to abuse than calculated to answer any good purpose. An attempt to fix the boundary between the regions of ability and inability would much oftener give scope to personal and party attachments and animosity than advance the interests of justice to the public good, which means that the reason why we cannot remove justices, including the Supreme Court justices, is because if they think that they can be removed, then they won't do their job good. That makes no sense. But that is originalism, and that has been positioned through Congress decision-making, but also judicial decision-making. When it came to the immunity decision, they said that if a president doesn't have immunity, then they won't want to give a peaceful transfer of power because they'll be scared that they'll be prosecuted. It makes no sense, but that's originalism. That is not constitutionalism. That is identifying our experience based on what our founding fathers in the 1700s wanted us to do. Going back to the Electoral College, you may ask, why was it that they were so adamant in putting in the Electoral College? One, obviously, the states, the southern states, were really scared that they would not be capable of controlling the public discourse, the public opinion, and as such, they wanted some control to filter out the decisions of the voters. But allowed for even the critics of this to say, okay, I guess we can do that, is Shays' Rebellion. Shays' Rebellion really was the one that actually positioned for our forefathers to ditch the Articles of Confederation, which is our first constitution, and create the United States Constitution in 1787. Shays' Rebellion, think of it as like if Occupy Wall Street went and tried to take over an armory of the United States. The federal government couldn't do anything because in the Articles of Confederation they were really weak. The states didn't want to give them any power. So when we went into the United States Constitution, the states didn't give up power, but the people did. We know that because of we the people. Yes, the representatives were the ones who decided it. But words matter. When you sign a contract, you are liable to what's in the contract. You're not liable to what you think you signed, but what's actually in the contract. So what they put in the contract is what should be our reality. The reason why we don't have freedom but liberty is because our liberty can be restricted. Freedom cannot. We know that because of Federalist 2. Nothing is more certain than the indispensable necessity of government, that whenever and however it is instituted, the people must see to it some of their natural rights in order to vest it with requisite powers. And you may say suffrage is a democracy principle, but actually Federalist 52, the definition of the right to suffrage, is very justly regarded as a fundamental article of Republican government. There'll be more parts to this, but I want to end with this. Federalist 78. Until the people by some solemn and authoritative act, which is Article 5, annul or change the established form, it is binding upon themselves collectively as well individually, and no presumption or even knowledge of their sentiments can warrant the representatives in a departure from it prior to such act, which means we have to invoke Article 5 in order to even be capable of progressing, because if we just do legislation, they can just do it invalid by the courts, which they have conservatives. If we do it through the Constitution, they don't have any power over that.